Hi, friends and subscribers of the channel. So, today I wanted to talk about being a witness in a court. I mean, how often do we find ourselves in a court? Maybe not so often, but whether we like it or not, now and then we find ourselves having to appear in a court or to give a testimony in court. Either you're as an accused, you go and testify, or as a witness, you go and testify. So often people, when they get to court, they are very intimidated. I mean, there's this judge that's sitting in front of you, or magistrate, or whoever he is, that's you know all dressed up in all this regalia. There's your counsels are there. In a criminal case, there's a prosecutor, there's a the defense counsel, and they also equally roped up. It looks so professional. I mean, it really looks intimidating, isn't it? And there's a way, titles are used, whether it's your worship, your honor, your excellency, judge, whatever term that is used. So it's a very intimidating environment. So I just wanted to, just share a few things that might assist you to be comfortable and to relax. And next time, when you appear in any court, you'd be able to do it without even flinching or worrying too much or stressing too much. And obviously, depending on whether you are an accused, for example, in a criminal court where the stakes are very high, or whether you are a witness, the stress levels and the pressure will be very different. But either way, these are general principles and they will help you at least be in a better position to tell your story the way, either if you are a party that is involved, the way it happened, whether you are a complainant, you are an accused. But if you are also a witness, you can tell your story in terms of how you saw things that happened, you know. So, as a result of that, I thought that it is very crucial that I share the following points. The first point is you must accept and understand that all court functionaries, including the presiding officer, are human beings, and you must see them as such. And they have nothing personal against you. They are there simply doing their work, and counsels as well, prosecutor, defense counsel, or whether it's in a civil matter where both counsels are there. They are just there doing their job, and they are not there to destroy you, to intimidate you, to abuse you, but just simply to facilitate the two stories effectively in order to enable whoever is the presiding officer to make a decision regarding what is happening. So, what are these basic things? One, go to court, and when you arrive there, be as early as possible, because you don't want to arrive there late and the adrenaline is rushing and all these things. Take your time, arrive early on the day in question, and then relax. When it is your turn to come and testify, you will be called to the stand. And when you are now on the stand, these are the tips now where that's important. Just go there and tell your version, the truth. There is nothing other than telling the truth. And the truth, what I like about it is it does not change. And the problematic issue would be when you go to the stand and you start telling lies, and then when under cross-examination, obviously it's easy under examination in chief, you've prepared your lines, what. But immediately when you go into cross-examination, then the whole thing changes and you start being exposed as a liar, and that's not a good thing. So the easiest way is to go to court, tell your story the way you know it and how you believe it happened, not how you in fact you believe it happened, how it happened. That's it. And the first thing is, when you have, let's say for example in a criminal case, the prosecutor is asking the question, look at the prosecutor straight in the eye. Listen carefully to what they are asking. When you respond, you look to whoever is the presiding officer straight in the eye and you give the response. If you did not listen or get the question clearly, you are allowed to request whoever is asking the question to rephrase the question, to repeat the question, or to use, for example, words that you would understand. And if, for example, English is used, do not be afraid to request a translator. Do not be afraid to request a translator. So if you are an Afrikaans speaking person, Zulu, Xhosa, Venda, any official language, request the use of an interpreter, because then you can speak in your own mother tongue, and then the whole proceeding can be really nice and relaxed, and you can feel like you are in a better position to express your ideas, your thoughts, be able to express how certain things happened, and without struggling too much. And then the other thing that is important is, don't listen to the question and then halfway you're already wanting to answer or already thinking about the answer. Take your time, wait for whoever is putting the question up until they have finished with their question. Take a few seconds thinking about the question, processing the question, and whether you understand the question, and then answer the question. If they are trying to ask too many questions all at once, ask them to say, can you please break down the questions in a way like, short questions, small questions, but any professional prosecutor or counsel for the defense would understand all these dynamics, that they won't ask a long-winded question. They will break it up into smaller questions to be able to extract easily the necessary information. So that is a very important issue. And then only answer the question that is asked. Don't try to be, to volunteer unnecessary information that is not solicited from you. Listen to the question that is being asked and only volunteer that information. That is very critical. And I've already emphasized another tip, which is to say, take time and think about your question, digest it properly, and only when you really understand the question do you then answer. If you don't, you ask them to rephrase or to repeat the question. The important thing also is that don't attempt to guess the answer. Either you know the answer or you don't know the answer. If you know the answer, just give the response. If you don't know the answer, just say, I don't know. But don't try to be creative and making up answers, because you will be caught in your lies. And the important thing also is that there is nothing wrong for you as a witness to say, I do not understand, I do not remember, or I never saw it, or it did not happen. So it is not bad. In fact, it is preferable for you to say you don't know if really you do not know. Then the other thing is important is that request clarification if needs be. Request clarification to the question if needs be. But the worst mistake that you can make is to try and answer a question that you yourself don't understand. It is very problematic. The whole idea is you as a witness must be very cooperative. Cooperate, and where you are asked your own general understanding or your own view about a particular issue, give your honest view. Don't try to anticipate how that information is going to sound like, how it's going to be used. Just answer honestly and truthfully how you what you believe or think, or how you understand things to be. And this is a very crucial thing. Often the difficulty that people have to express themselves in court or to speak easily in court is that they worried about what the impact of what they're going to say is going to have on the broader case. And that is when really you dig a hole for yourself and you mess things up. The other issue is, don't try to be arrogant with the person that's asking you questions, or try to to be angry because the questions that you are being asked are uncomfortable, or perhaps you believe that there is unnecessary repetition. That is not important. Be patient, be calm, be courteous, be respectful, and answer the questions that you are asked. The other thing is, don't start, you have to be consistent in your testimony. Don't say A and then suddenly you are on C, you are on D, and then suddenly everything is completely confused. So it's important that you understand, because if the truth is what you're going to testify, certainly the truth must be consistent, because truth doesn't change. Lies, 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 lies. With lies, I can't advise you. One, it's you should not be telling lies under oath. Remember, you will still be under oath. So it is not recommended, at least by me, that you lie under oath to either support your body, or either you don't want to get in trouble, or for whatever reason. And so that is important. And lastly, friends, what I'll say to you is that stay relaxed and understand that you are helping the court to come to a conclusion or to do their work, and you must try your utmost best to be as cooperative as possible, as truthful as possible, and give as much relevant information as possible. And in all of these also, if you really forgot, I'm sure in consultation you can request to refresh your memory, because sometimes from the time the person either is charged or the case starts and to the time that it's actually been dealt with, quite a stretch or a time can pass, and that is not nice, especially because we know that memory is very fallible and we forget as human beings. And if you genuinely forgot something, indicate it. It is not a bad thing. The courts are there to ensure that there is justice, and sometimes justice means that the person who has a debt to society pays that debt, or a person who has a debt to another individual pays for that debt. And that is how we correct the injustices that are there. So it is important, ladies and gentlemen, as I conclude, to say thank you very much for listening to me. And next time when you are in court, don't be intimidated. Understand that the people that are in that courtroom are human beings. That is the father of somebody, the child of somebody, the daughter of somebody, and they have the best interest of justice at heart. There will be definitely a next video coming up, and I am sure that you are looking forward to it. Thank you very much. Till next time. Bye-bye.